diplomat. So we'll be making sense of all those issues tonight after the Frontline trigger.
Frontline. A twist in the Kyagulanyi election petition as one of the former candidates in the recently concluded presidential election, Willie Mayambala, applies to Supreme Court to ask to take over the case. Obviously, this is history in the making, as it becomes the first time that a presidential petition is withdrawn, and it is also the first time that another applicant comes up to take over a withdrawn case. In a letter dated 25th February 2021, former presidential candidate Willie Mayambala has written to the Supreme Court in what he called objection to the withdrawal of the presidential petition, seeking guidance to inherit the same.
And I am here to object to the withdrawal of the Kyagulanyi petition, as well as to seek guidance on how I can be allowed to take it on to conclusion. It's a sign of cowardice, withdrawing from a case which is of national interest. Everywhere I go, Ugandans have been asking me, why don't you stand behind the Honorable Kyagulanyi? And my response has been, they need to talk to Kyagulanyi to invite me on board. If he's not inviting me on board, I will not invite myself. But now that he's withdrawing from a matter that concerns the ordinary Ugandan, a Ugandan like me, I can't just sit back.
As the country awaits the decision of court on the withdrawal and then inheritance, several questions remain unanswered. First, why did Kyagulanyi try to withdraw the case after all the time spent filing? And then, what interest does Mayambala have in inheritance the Kyagulanyi petition? The answers to these questions lie in the minds of the justices of the Supreme Court, Robert Kyagulanyi and now Willie Mayambala. Away from this, Kyagulanyi has hinted that his only hope now lies in the court of public opinion.
Decided to withdraw from their court.
Then we ask, does this exist? Has this been tested and proven to provide the answers that the Kyagulanyi petition dilemma poses? Or it's only providing hope to those who don't want to see President Museveni sworn in May?
President Museveni in 1980 stood with the Honorable Sam Kutesa, now the Minister of Foreign Affairs, for a constituency. The Electoral Commission returned results and said Honorable Sam Kutesa had defeated President Museveni. President Museveni actually filed a petition. But within 1 month of filing the petition, he picked a gun and went to the bush. That can only tell you that he did not have confidence in the court system. What then was the result? A 5-year civil war. Thousands of people killed. Properties lost. People fleeing into exile. A lot of human suffering for 5 years.
We put these and a lot more into perspective. This is The Frontline. Frontline.
All right, streaming live from Plot 13, Summit View Road, the home of NBS Television. Welcome to tonight's edition of The Frontline. We're also live on 106.1 Next Radio. And a warm welcome. Thank you for joining us tonight. We'll be making sense of the big story of the week. We'll look at the politics, the legal dimensions, and as well as the consequences on the way forward as a country. Tonight we ask whether it's that time when we say congratulations to General Yoweri Kaguta Museveni officially. But a lot more, we'll be looking at that. I have 3 advocates of the High Court in studio. Will be benefiting from their school fees for free. The Honorable Norbert Mao, President General of the Democratic Party. I was not
1994.
Since 1994. All right, we have Counsel Hussein Kashiringi, advocate, but also one of the lawyers of the president who was representing that side in court. Welcome to The Frontline, sir. We have Advocate Honorable Samuel Odongao To, the loud voice from Aru County.
Future former MP. Future former MP.
All right, you still have a couple of months. And once Honorable, Always one. And one of the people we'll really miss in Parliament, as the parliamentary press, is Samuel Odonga Oto. Mr. Ofono Opondo Podel, Executive Director, Uganda Government Media Center, and Frontliner, thank you for your dedication, sir. And the Honorable Beatrice Kiraso from Renewed Uganda. Thank you, ladies and gentlemen, for joining us tonight. Let's start with the latest developments in regard to the proceedings in court. One, Willie Mayambala, a former presidential candidate, has written to court seeking guidance that he wants to inherit. I don't know if that word exists in law. He wants to inherit the Chagulanyi petition. I'll start with you, Honorable Norbert Mao. What do we need to know about that process?
It is a party to a case who goes to court to do two things: to seek redress for a grievance or to assert a right. In this case, the new presidential candidate went to do both. You know, free and fair elections is a constitutional right. So he went to assert that right, and by saying that right was violated, he also went to seek redress for a grievance. By the accounts we have had from his campaign headquarters, he pleads that he won the elections and that he should have been declared. So that is the basis of his grievance. He's aggrieved that the... No, we are talking about... Mayambala is still in the veranda of the court. He is not yet before the court. I haven't yet seen him interacting with the court. So he went to assert a right and to seek redress for a grievance. One of the things that Ugandans need to know is that even the state can arrest you, take you to court on criminal charges, and later withdraw the charges. It is in the law. It is not such a, it's not like the sky is going to fall if you withdraw a case. Government is always withdrawing cases. It is called nolle prosequi. The state can lose interest. Even a party can lose interest in a case. So this is something which is within the law. But of interest is the kind of tension we have had between various parties and the court. Many times we celebrate the court when they agree with us. Then we denounce them when they disagree with us. The other thing Uganda needs to know is that judges are not from Mars. We cannot expect judges to be neutral. We expect them to be impartial. In other words, judges have opinions. Many of the judges have published books. Let me use the example of America.
Not Gulu this time.
Of course, Gulu is better than America. I will use that example when we are talking about the transgressions of those fighting democracy in America. Yes. So the thing is, when you are appointing a judge, you appoint a judge who is aligned ideologically to what you believe in. So I do not like this idea of people thinking that there is some ideal world.
All right, let's get into those issues. Let's first establish conversation. Those are the issue. We have 2 hours tonight to look into them, and we'll try to use our clock at 3 minutes so that we get the conversation more lively. Mr. Ofono Opondo, the news of someone wanting to inherit the petition, how do you receive that?
Well, the lawyer who got enrolled in '94 skirted that one. But I think in this particular case,
That is also within the law, by the way.
presidential election petition, indeed it is true, a party to a case can withdraw, but there is specific condition to that withdrawal. Prominent among them, I think, are two. That you, the petitioner, in this case, Robert Kyagulanyi, should write to court giving reasons why, and then his lawyer too should write to court. In short, the lawyer and the petitioner should agree and write to court so that there is no possibility of a claim that I withdrew because I was perhaps intimidated, or somebody alleging you were bribed with a bulletproof car and that's the reason you are withdrawing, maybe, and things like that.
Oh, where is the car coming from?
Well, it is in the news, in the social media. So the framers of the law were very careful so that, because presidential election petition is really a serious matter. First of all, you make all sorts of allegations about the credibility of the electoral process, the electoral commission, the presidential candidate that has won, the voters that voted, and then, of course, the money. So the framers tried to make it difficult. You don't withdraw on flimsy excuses, but also you don't use it to throw about allegations of, say, you were compromised or you were intimidated. So in this particular case, Robert Kyagulanyi requires to write to court, both him and his lawyer, Segona. I don't know why his lawyer advised him, or if indeed advised him, to use the press conference initially, rather than going to put record in court why you disagree and why you are withdrawing. The first instance here, you should put in court. So there is mischief there, maybe a publicity stunt in this petition. Now, about Mayambala. Mayambala hasn't said he's seeking to inherit. He's asking the court to give him advice. I am not sure if that is provided for, that the court should advise you whether you should come to court or not. The lawyers will help me understand that one. I don't think it is provided anywhere that if you want to go to court, you first ask the court for permission. In effect, that's what Mayambala is doing. And to that extent, I think his request is really superfluous. Maybe he's also seeking attention.
Okay, thank you. Let's go back and use the Honorable Dongaoto's school fees. The issue that OO raises, someone writing to court to advise them. Your take on that, Honorable Otto?
Yeah, I've seen senior counsel, the one who has personal brief in the case, is here. He's hands-on, he's just from court. But I know I will give his opinion later. But what I think, to begin with, when I was leaving law school.
All right, Honorable Otto, just hold it. Let's take a break. We'll return in a bit. We need to rectify a technical issue there.
Frontline. Stay connected to the largest 4G network in Uganda, anytime, anywhere, using the Airtel 4G Pocket MiFi, available at only 123,000 Uganda shillings. This comes with 15 GB free, valid for a month. You can connect up to 10 users at a go and still enjoy a shared yet unmatched internet experience. Dial *175*9# to activate free 15 GB. Visit the nearest Airtel shop to get one today. Airtel, the smartphone network. Airtel is regulated by the Uganda Communications Commission.
It's a brand new day, yeah. Let your beauty show as your hair glows. With Radiant, everything comes to life when you arrive. And should you ever look back, let it be to gaze upon Look good, feel great.
Today tastes like a new tradition, like an old favorite. Tastes like all hands on deck and all eyes on the prize. Today tastes like a piece of the action. And it never tasted this good.
We improve your lighting experience. Come to Chint today to get all the electrical supplies you need. One source, total solution. Switch to
NBS Frontline.
Welcome back to the conversation. The hashtag is NBS Frontline on Twitter. We're looking at the conversation happening ahead of a decision that is pending the Gazette. The publishing of the intention to withdraw in the Gazette and the latest developments. I will respect the decision of those who went to law school for very many years. They respect seniority in their courtrooms. So I'll ask Counsel Sen Kashiringi to speak to that matter. You're one of the lawyers in court representing one of the parties. How do you receive the news of Mr. Willie Mayambala writing to court to advise him on how he can inherit the petition?
Thank you, Joseph, and good evening, viewers. Now, the Presidential Elections Act under Section 61 allows a petitioner first to withdraw a petition by stating the reasons for doing so, and then court will go ahead and hear that application. And if they think that the reasons are good enough, they can grant him leave to withdraw, or they might in fact refuse to grant that permission, that leave. But once that leave is granted and he withdraws his petition, then any other person who was a candidate in that election together with the petitioner may apply to court and ask court to allow him to inherit that petition so that they can go on to the end. And I think now I've seen a letter from Mr. Mayambala seeking court's guidance on how he can be allowed to inherit the petition. Of course, number one to note is that this petition is still in court, so it has not yet been withdrawn. Leave hasn't been granted because the process of withdrawal is not yet complete. The petitioner filed an application asking for withdrawal. It was supported by his affidavit, that's Honorable Chagulanyi. And then his counsel, or one of them, was supposed to also swear an affidavit. By the time we were in court the last time, he hadn't done so. So he was given up to the end of that day to file his affidavit. And then after that, we, the respondents, would also have to file either opposing the application for leave to withdraw or consenting, and we were given up to Sunday, so that then if that is all done, the registrar of the court would cause that application for withdrawal to be gazetted, and once it is in the gazette before Sunday, then the Chief Justice directed that we should be ready to hear the application now on Monday.
Okay.
So the application has not been heard and leave has not been granted, so Honorable Chagulanyi's petition is still in court.
So where do we put Mayambala? At the veranda of court?
As Honorable Norbert Mao said, Mayambala is still in the corridors of the court. He has written a love letter to the court,
Chief Justice, yes.
asking for guidance. That also should demonstrate either his seriousness or lack of seriousness, because how does he inherit a petition without counsel? So probably counsel should have written on his behalf or advised him. He should go to a chamber and be advised instead of asking court to advise him. But right now he's still not anywhere. But if he's to be allowed, he has to make a formal application stating the reasons why he wants to inherit the petition. And we are not yet at that stage.
All right. Would you want to pursue this case up to the end?
As respondents?
Yes. What decision have you taken? Are you going to oppose?
No, if the petitioner withdraws the case, why would we want to pursue that? It's not our case. It's not our case. It is Honorable Chagulanyi's case. So if he says, I'm no longer interested, why would we show interest? We won elections on January 14th, so really, why would we want to be in court?
All right. Honorable Otto, your take on the developments.
Thank you. Last week I saw an advert in the newspapers. They were advertising for judges. They needed more judges.
Yes.
And this one, my good friend Ofondo Pondo, should know that politics aside, some of us having practiced law for 10 years, we can even apply to become a judge. I qualify, so we should also, but that aside.
Justice Odonga Otto in the
that aside. No, that is for another day. Yeah. But what I think, as long as we continue asking the wrong questions, we are not going to get the right answers. The question to me is, why did Bobi Wine withdraw? Okay. He cited several reasons in the media. Of course, my good friend Ofondo Pondo said he did a media stand. The procedure for withdrawal is very clear, the way my senior learned colleague Kashiring has just stated. So in other words, to the lay people, get it well, Bobi Wine is still in court until he's formally discharged. This is in the law we passed. So to me, I think the bigger question should be, someone is crying foul, someone has been under house arrest, he was released, he had few days to organize to file a presidential petition. Don't forget, in the last presidential petition of Kiza, Besigye, and Museveni, the judge, I was in court, the judge said there are areas of the law that needs amendment. And he advised that if Parliament does not amend these sections, the presidential petitions will not be fair to the petitioners. And one of the sections that they asked Parliament to amend was time for presenting petitions. There are 124 districts. And you expect Bobi Wine, who has been under house arrest, to file a petition for the entire country in about 2 weeks. That means, like my good friend Mao is doing, if you're campaigning in this district, you should also be collecting affidavits concurrently, knowing that when you lose, automatically you'll have to file a petition. So Bobi Wine did not have enough time to get all the affidavits. So in my opinion, when he asked for an amendment for extension of time to bring additional evidence, the court should have allowed. When I was in law school, I was advised, I think by then, now it's Justice Kakuru, said, Honorable Tau, if you agree with the last court of the land, the only place you have is to go to the bush. So this election petition before a quorum of 7 judges. Nine. This is the highest court in the country. So they should have been very accommodative to Bobi Wine, because where else can Bobi Wine go? Where else? Can he go to Garamba and join Joseph Kony and start fighting? No. So for the court to say, we are not allowing additional evidence, even if it was time-barred. My senior colleague, Kashiringi, was just telling me there are time lapse given in the law. It's true. But also the same constitution, I think under Article 27 says access to justice should not be denied because of technicalities. They should have allowed Bobi Wine even to bring trailers of evidence. In any case, all those judges were appointed by President Museveni. So to me, much as the withdrawal has kind of bruised the judiciary, I think Ugandans should be very slow to destroy the judiciary.
Okay.
In my opinion, they must be very slow to bring the judiciary into politics, because the moment the judiciary is dragged into politics, then we will have anarchy. Before coming here, I was reading the judgment of Justice Owindolo on the Al-Shabaab terrorists. Just go and read that judgment. You may think it is Lord Denning. You may not believe it is a Ugandan that passed that judgment, that got those terrorists imprisoned. So when we are disagreeing with the judiciary, then we have funny letters, love letters from the Malay, this called Mabirizi.
Mayambala.
No, the other lawyer,
Malay Mabirizi.
Mabirizi. You see, when the judiciary does well, like on issues of terrorism, no one thanks them. When they're being dragged into politics, people bring personal matters. I think we must be very slow, because the moment we drag the judiciary into politics, tomorrow you will have a court order against Ufondo Pondo. You will not arrest him.
All right, thank you.
I hope you will give me time to explain the issue of time.
Honorable Beatrice, how did Renew Uganda receive the news of the intention to withdraw the application and the developments?
Oh. Joseph, I want to say something similar to what Honorable Dongoto has just said. Flexibility. For me, 2 wrongs do not make a right. If somebody is wrong, and then you are also wrong, and you are not supposed to be at the same level, you are expected to have at least a higher, not moral ground, but a higher level of tolerance and understanding and respect, for that matter. You behave differently. It is unfortunate that it came to withdrawing a petition. Even the NRM side that says they won elections on the 14th, with what is going on in the country, with the impasse, with the anger, with so many things that are going around, I think it would have been in the interest of NRM as well, and those who support them, to have this concluded and probably legitimize this win. It's not funny that an election petition gets withdrawn, and then we laugh about it and trivialize it and say, after all, he didn't have evidence. Why did we not allow him to go up to the logical conclusion of the case that he filed? In which case, therefore, the courts of law could have been a bit more relaxed to avoid showing partiality. And when I say 2 wrongs do not make a right, I have a lot of respect for Justice Owini Dolo. But there are some utterances that should not have come from a Chief Justice. When you tell a petitioner, a politician, because you've heard he talked about Plan B, and I don't know whether he's the one who talked about Plan B, but as far as I remember, I think it is Dr. Kiza Besigye who did. When you say, I'm not going to excuse myself, if you want, you can go for your Plan B. Really? You know, you reduce the whole thing to like people who are grazing. Eh? You throw a word, another one throws another one from one hill to another hill. I would have expected our respectable courts of law to act differently, to give a different impression to the petitioners and to us, the public. But that impression that was given was not the right one. And so therefore, how have we received the news of the withdrawal of the petition? One, with sadness, because I think the person who got up and said, I'm going to petition, meant well for himself and for his cause. It was the right thing to do. If you are aggrieved, go to the courts of law. But clearly what he's showing is that, look, I've not been treated fairly, I'm pushed to the wall, and I have no alternative rather than to withdraw my petition.
All right, Councillor Kashiling, the question of timelines in the Constitution vis-a-vis the need for justice and fairness. Let's speak to that, the issues that people here on the panel here raised.
First, Joseph, I am an officer of court, so I feel a little compelled to come in here on the side of court. I think that court is being bashed rather unfairly. And I think it's probably due to limited information. Let's look at what happened. Honorable Kyagulanyi filed a petition. From the time we held the election, he had 15 days within which to file.
10 days under detention.
He had 15 days within which to file a petition. And so you say he was detained
for 10.
But during the time that he was under that house arrest, he had full access to his lawyers.
That's not entirely true as well.
And no, this is in court, it's on record. And he had access to his lawyers, and lawyers are the ones that file petitions on behalf of petitioners. And what the lawyers decided to do together with their client or petitioner was instead to file an application for his release, or, from detention. And that was done. And then after that, they filed a petition. When they came to file the petition on the last day, the Chief Justice said, it's okay, it's a weekend, you can come on Monday. So he gave them 2 extra days. You can come on Monday, and allowed them. So he gave them extra 2 days. Those are 17 now. So they came on February 1st and filed a petition. They served us with a petition. After serving us with a petition, the law requires us, upon service, to respond within only 3 days. 3 days for the respondents. He has had 15, plus the other 17, we had only 3 days to respond. We did respond. After we put in our response, the petitioner applied to court to amend his petition. And why did he apply? Because he was out of time. The time that is set by the law was done for the petitioner. Once you have filed a petition and you have served the respondents and they've filed their answer, then time for you to amend is done. So he applied for leave, for court to grant him leave to amend. And we had that application. During the hearing of that application, the petitioner's counsel argued that he had time in detention and so did not have sufficient time to collect evidence. But I want you to understand this. Then they stated on the record, and which was from his affidavit, that but when High Court released me, I was able to traverse the country and I was able to collect evidence, which I now have, and I want to file it. Are we together? So he says, I now have the evidence that I was not able to have when I was in detention. But when High Court released me, I was able to traverse the country and I obtained this evidence. I now have it. Please allow me to file it. So the judges, we argued the application, we opposed it, because we thought, first of all, the law was that it was out of time. Okay. But then the judges said, in denying that application, they said, a host of the things that you have included in your proposed amendment includes evidence of non-compliance with the election. And yet, in the main petition that you filed, that was on 11th, up to that point, you have not yet filed evidence for that petition. Yes. And your ground was non-compliance. So why do you want to amend the petition to bring evidence which you have not yet even brought in the main petition? So Justice Aracha Moko, reading for the majority judges, said, please, this evidence that you have now collected, please file it together with the evidence in the main petition. So I would like the public service to know that the judges did not refuse that evidence. They said, please file it, because at the time he was making that argument, he had not yet filed any evidence. Okay. Now, just a second. On that very day, lead counsel, Honorable Segona, whom I have profound respect, my classmate, said, my lords, I have 50 affidavits ready today to file. In fact, by close of business, I will have filed 50. Tomorrow, I will put in the other 50 and our case will be done. I will even donate some time to the respondents. That's what Honorable Segona said. This was on 11th. Then the judges said, it's all right. Even if you say you are ready today and by tomorrow you'll be done, we are giving you up to 14th. This is the court that people are mistreating. That's what the judges said. You have until 14th to file everything. 14th, 5 o'clock. Sabit, on 11th, when Honorable Segona said, I have 50 affidavits today to file, he never filed them. And on 14th, 1 minute to 5 o'clock, is when they filed 53 affidavits.
All right. Honorable Otto, does that answer your concerns?
I don't have sight problems. I don't use glasses.
I do.
I saw on NBS television where Justice Aracha Moko was saying your application is rejected. It was on the news. So yes. what Kashiringi is now saying is different from what we saw on the news. Did the TV lie?
That's what
it was clear in the news that the application was rejected. In the news.
The reason for rejecting was please file your evidence in your petition.
The point that probably...
I think that for the record, the application for extension was rejected by court.
Yes.
To that extent, that's a fact.
For the reason...
I'm saying the fact is that the application was rejected.
It's important to know.
That's the order of court.
Before you go to the reason, Hussein, you said court did not reject. But anyway, Joseph, do we really think that the population, people who are awake at this time listening and watching us, they want to get those nitty-gritties of the Constitution and the law and who failed what and who said what? Because...
But that's why we are here.
I don't know.
Why are we here?
All right, let's listen to Honorable Otto.
And
we are here to educate the public.
You can talk about... You know, there is this joke, you know, in law where they say the lawyers were arguing obiter dicta, mens rea. Then the old man was listening and saying, can I say something? Do you know how far the ant hill is from the other tree? Because that is what he knows, that his land stops near the ant hill. You people, you talk your law there. So Ugandans out there, you can even argue in the best English.
Yeah.
But out there they say, Bobi Wine brought new evidence and you refuse to listen to it. That is the main question, and which has to be, and became frustrated and withdrew. So this one probably,
but why don't you want
we need political answers. The legal ones, Ugandans are now like people saying the ant hill is near the tree. They don't want your jargons and with the necktie. So why did you stop him? Where did you want him to go? You have tied his legs in chains. The young man cannot move. And then he has 15 days to bring affidavit, and the previous justice of the Supreme Court told Parliament to amend the law that 15 days is not enough. It is on the record.
It was actually amended from 10 to 15.
Yes, even 15 is not enough. You need like 45 days to bring a reasonable presidential petition.
That was your job, Honorable Otto.
Yeah, that was my job. So all I'm saying is, we should have allowed, in any case, you see, it's like driving from here to Luero, Ladit Sabiti, and you know your fuel cannot reach. For me, I know that in the final judgment, it will still be the usual maths, 3-2. They should have allowed Bobby Wine go all the way. It will be a therapy. Half of the society still believes in the judiciary. Then you make him fail in the final petition. Anyway, did you expect Bobby Wine to win that the judges said the elections were unfree and fair and we call fresh elections? That one should not even come in your wildest dreams.
Because if you're an officer of court.
If you have started dreaming like that, there is what we call Kelsian theory. Ask Mao, ask Kashiringi, ask me. We are trained in law school, what they call jurisprudence. When there is law, when there is semblance of law and order, you, a judicial officer, must not cause anarchy. People are going around their normal business. People are following traffic laws. We are trained not to nullify elections in such circumstances. It's the Kelsian theory. It's the principle of law. So I did not expect the judiciary to say the elections were unfree and fair. It's not possible. That's not our training.
Okay.
Honorable Mao would agree with me.
Listen to Mr. Ofono Pondopodelo.
You see, it is very interesting that lawyers and officers of court are now inviting the bench to disregard well-established, first of all, the law, but also well-established procedures and precedents. Even when the Constitution says substantive justice should be delivered without undue regard to technicalities, does not mean that there is no strict parameter which the courts should follow. So I'm amazed. Now, secondly, Odongoto is talk about principles of law. In management, there's something called Parkinson's law in management, that the amount of time you have should be adequate for the amount of work you have. That's why in school, you can do the same question in 1 hour, in 3 hours, or you could be given as an assignment for 1 month, and you return after 1 month when you haven't answered the questions.
It reminds me of Professor Juko. He would give you the question
yes.
one week in advance.
Yes. So we must deal with the question of time as set by the Constitution and the law. But let's go to the politics of it, if Odongoto was asked to discuss the politics of it. What did Kyagulanyi himself say? First of all, the record of court, which Counsel Kashiringi has adequately and accurately quoted, that his lawyer, Counsel Segona, told the court that they have gathered enough evidence, enough affidavits, and they are ready to file. And indeed, partly they failed to file, although they had said so on that day, but subsequently they filed. Secondly, Kyagulanyi himself told the media, if Odongoto says his eyes are not colorblind or whatever, he doesn't use glasses, Kyagulanyi himself told the media and the world that he had gathered 450 affidavits. Thirdly, in our judicial system, we have people who are outside of Uganda. Don't their lawyers present cases on account that they are outside Uganda? No. You see, there's an argument. You
want to separate that with the presidential election petition because it is person to hold.
Yes, listen. No, even the others, because the contention is you are trying to make a claim that Kyagulanyi was under house arrest for 10 days.
That's a fact. It's not a claim.
And therefore, he could not get the evidence. But what does his own lawyer say to court, which is the record of court, that they have sufficiently gathered enough evidence?
After his release.
That's the evidence in court. Two, Kyagulanyi himself then comes up and says, no, not just 50 or 200, We have actually 450. So who are you now to say that Kyagulanyi did not have sufficient time when in court his lawyer and him have said they have gathered sufficient evidence? Never mind that the rules allow amendment and so on and so forth, which the judges can deal with. But that is the evidence of the petitioner and his lawyer. So why are you disputing, why are you trying to impute that his 10 days or the remaining 5 days or plus the 7, as the Kashirinji says, which extended to 17, did not provide him with sufficient time? The record in court is that the lawyer is saying they have sufficient evidence. I suspect, and this is the question you had asked earlier, why do people go to court? People go to court for various reasons. Some stated, others not. Kyagulanyi himself stated that the reason for going to court was to expose and embarrass the judiciary.
Expose was the word. For the record, yes.
Expose and embarrass. You chose maybe not to edit the embarrass.
No, I'm saying what is on record is expose.
You are not the only one who listened to him. I also listened to him, and I'm saying to expose and embarrass the court about its bias. Yes. That's what Kyagulanyi said. Clearly, it means that Kyagulanyi did not go to court, as the lawyers say, with the clean pairs of hands. He had other mischief he wanted to deal with. And therefore, I read in this going to court and the antics in court, perhaps is a patchwork of his lawyers.
And the drones.
No, he made the point. Patchwork of his lawyers not gathering and adducing credible evidence, as we have learned subsequently, for example, that some of the affidavits have signatures that don't tally with the alleged people who deponed the affidavits. That's true. Forgeries. My own reading, because in the court, they found that out of the 50 affidavits examined, subjected to handwriting experts, 2 handwriting experts, majority of them were forgeries, were of non-existent voters, and so
handwriting expert who are government employees,
and so I suspect that apart from his intent allegedly to expose the bias of judges, chances are that he's running away from his case because he knows in the court things are going to be put to strict proof, which would embarrass him perhaps by exposing some of the running mischief in that petition.
Honorable Norbert Mao has listened attentively. You'll have the last word on this. Then we talk the politics way forward after the Supreme Court issues.
I don't want to constitute myself into a Supreme Court judge here because people here are talking as if they are judges. I think you have neglected one aspect of the time. The law provides that you must file your application within 15 days, but the judgment must also be delivered within 30 days.
Is it 45 now, Councillor Kashilingi?
45.
45 days. After
it was extended, yeah.
Yes, extended to 45.
45 days. You now know how cases are complex and how time lags, and my own case has taken 5 years even to come before a judge.
You have a case?
Yes. I was also in hospital and I was not registered to vote. While other people who are privileged, the fingerprint machine was taken to their hospital beds and they were duly registered. And poor me, who even had a conversation with the vice chairman of the Electoral Commission, I was denied that privilege.
Do you want to add that you had stood for a boycott of that process earlier? For the record.
I was following the able leadership. I was following the able leadership of Kanokiza Besigye.
I just wanted that on record that you had actually boycotted.
I have been saying it all the time.
Yes.
So anyway, the point is that as a lawyer, I know that a case is like a door. It turns on some hinges. It is not even the quantity of affidavits that win a case. If really anybody wants to know for sure. I had a long chat with Justice Kanyehama. They asked him, what would you have done? He said, I would have also rejected those extra affidavits.
Yeah, he actually gave an interview.
Yeah, and he made it later public, and he said Honorable Chagulanyi was a great petitioner who had lousy lawyers. As a straight talker, that's what he said. The other thing is, in terms of management of public affairs, unless you really want to do something else which is outside the status quo, if you have lawyers, the good thing is to let the lawyers do their work, because if the lawyers are fighting in court, and then you as a client, you are also on a parallel process. And that's why the lawyers, some of them were also not aware that the client was intending to withdraw the case. One of the lawyers, the Honorable Medad Segona, was later interviewed, said, is that your advice? He said, well, if that is what the client's instructions are, we will see how to fulfill those instructions. So it is fair for us to say both the petitioner and the court are on trial. These are things that are about your judgment as a person, and also the court is on trial. For instance, what Justice Owindolo did, engaging in this exchange, I don't think it was necessary. It didn't add any value. Sometimes judges have the right to summon lawyers and their client to the chamber where the cameras are not there, and then they have a frank talk. In most cases, a judge can say, can you approach the bench? And then he tells you to your face when nobody is here that you know this thing. Yeah, he can even tell you you're a big fool. So, but I think there was a lot of provocation. Either way,
as Chief Justice, we expect better, though, isn't it?
It is a.
But you should also quote him in context. He said, we did not invite Bobby Wine to court.
Quoting news.